Converting a California C corporation to a Delaware entity is a common move for growing businesses, especially those seeking venture capital. But this process is more complex than many entrepreneurs realize. California is one of the few states that does not recognize corporate conversions to out-of-state entities. This means you cannot simply file paperwork to convert your California corporation to a Delaware one. Instead, you must create a new Delaware corporation and merge your existing California business into it. This merger process requires specific steps in both states. In California, you must draft a merger agreement, obtain board and shareholder approval, and file a certificate of merger with the California Secretary of State. Simultaneously in Delaware, you need to incorporate a new entity, adopt bylaws, appoint directors, issue stock, and file your own certificate of merger. While incorporating in Delaware is relatively straightforward, the merger process can become complicated. Existing contracts, stock arrangements, and asset transfers all require careful consideration. This is why most businesses consult with experienced corporate attorneys to navigate this transition. Why do companies make this move despite the complexity? Delaware offers several advantages over California. The Delaware Court of Chancery is a specialized business court with judges experienced in corporate matters, providing more predictable legal outcomes. Delaware corporate law offers greater flexibility in structuring boards and shareholder agreements. The state also requires minimal public disclosure of company information, offering enhanced privacy. For startups seeking investment, Delaware incorporation is often essential. Venture capitalists typically prefer Delaware corporations due to the standardized legal framework they're familiar with. This preference is so strong that many investors make Delaware incorporation a condition for funding. However, converting to Delaware does not free California-based businesses from California regulations. If your company continues operating in California, you must still register as a foreign corporation doing business in the state. This means filing annual reports, maintaining a California-registered agent, and complying with local business requirements. The tax implications are equally important to understand. A Delaware corporation doing business in California still owes California corporate income tax and the annual minimum franchise tax. You may need to file tax returns in both states, and the merger itself could potentially trigger taxable events depending on how it's structured. For businesses finding the conversion process too burdensome, alternatives exist. You might consider dual qualification, where you maintain your California entity while registering to do business in Delaware. Another option is creating a Delaware holding company that owns your California corporation as a subsidiary. The decision between California and Delaware incorporation should balance legal protections, tax considerations, investor preferences, and administrative complexity. What works best depends on your specific business goals, growth plans, and operational footprint. Converting from California to Delaware is not simply a paperwork exercise, but a significant corporate restructuring that requires careful planning and professional guidance. Understanding these complexities before beginning the process will help ensure a smooth transition that aligns with your long-term business objectives.